The Madlanga Commission heard fresh evidence today that cuts straight to the heart of judicial independence. A senior prosecutor, testifying under oath, described repeated attempts by political figures to influence charging decisions in high-profile corruption cases. The witness named specific meetings where ministers and party officials pressed for delays or softer charges, framing them as necessary for political stability. The Commission's legal team probed whether these interventions breached the National Prosecuting Authority Act and the constitutional guarantee of prosecutorial independence under Section 179. What stands out is not just the claims of interference but the institutional response. The prosecutor told the inquiry that internal NPA safeguards were bypassed through informal channels, including direct calls to the head of the Directorate for Priority Crime Investigation. This pattern, if proven, points to a deliberate weakening of the firewall between executive power and the justice system. South Africa's constitution places the NPA outside ordinary executive control precisely to prevent this kind of pressure. Testimony today suggests that firewall has developed cracks. The legal implications are serious. Section 165 of the Constitution vests judicial authority in the courts and demands that organs of state assist and protect their independence. When politicians lean on prosecutors, they are not merely breaking etiquette. They risk violating that duty. The Commission's evidence so far indicates that some officials treated prosecutorial discretion as a political tool rather than a legal function. That distinction matters. Discretion is exercised within the law. Political direction replaces it with something else. Commission counsel pressed the witness on whether these interventions amounted to an abuse of office. The answer was measured but damning. Files were moved, investigators reassigned, and timelines altered without recorded reasons. No formal directive was issued, which is the classic method for maintaining plausible deniability. Yet the cumulative effect is the same. Cases that should have moved forward stalled. This is the slow erosion of the rule of law. Not through legislation but through quiet practice. Critics will rightly note that one witness's account is not yet proven fact. The Commission must still test these claims against documents and other testimony. At the same time, the pattern described matches earlier evidence from the Zondo Commission on state capture. Repeating the same methods across different administrations suggests a structural problem rather than isolated misconduct. The rule of law cannot survive if each new government inherits the same temptation to control prosecutions. The inquiry also touched on judicial appointments. A second witness raised concerns about how shortlists for senior judicial positions were handled, alleging that candidates seen as too independent were sidelined. Again, the constitutional test is clear. Section 174 requires appointments to be made on the basis of merit and to reflect the judiciary's need for independence. If political considerations dominate, the separation of powers is undermined at its foundation. Fairness requires acknowledging that political actors often claim they are simply ensuring accountability. That argument collapses when the pressure is selective and aimed at protecting allies. The Commission's task is to distinguish legitimate oversight from improper influence. Today's testimony made that distinction harder to ignore. What the evidence means for the rule of law is straightforward. Institutions survive through consistent practice, not just written rules. When prosecutors and judges face credible threats of political reprisal, they adjust their behavior. The public loses faith that cases are decided on evidence alone. Restoring that faith will require more than findings. It will need concrete changes to appointment processes, internal NPA protocols, and perhaps legislation that criminalizes improper interference with a higher penalty than currently exists. The Madlanga Commission is exposing these fault lines while they can still be repaired. Its work is not finished. But today's testimony shows why the inquiry matters. The rule of law is not an abstract principle. It is the daily practice of refusing to bend legal processes to political ends. That practice appears to have been tested and, in some instances, found wanting.